So the state of New York's concealed carry law, which was temporarily restrained, is now once again up in the air. So let's talk about this. But real quick before we jump into this video, if you think states like New York need to stop violating our rights to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing civil rights attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state and national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is to give you insight into the inner workings of Second Amendment litigation so that you better understand what's going on in these legal battles over your rights to keep and bear arms. As I mentioned in the intro, in this video, we're going to be discussing the state of New York's concealed carry laws, which were found invalid and temporarily restrained, but then that judgment was also stayed pending review by the Second Circuit. The case we're going to be talking about in this video is Antioch v. Bruin. This case was led by GOA and was refiled after the same federal court judge dismissed the prior case for a lack of standing. If you don't recall, GOA sued New York because of their new concealed carry law, which they passed in direct defiance to the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruin. In Bruin, the Supreme Court struck down New York's May issue licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of the Bruin decision was that the government bears the burden to prove that their restrictions are based in our own history and our own nation's tradition. But another important thing that the Supreme Court did in that opinion is they stated a state like New York could not simply make everywhere with an entire state or an entire area a sensitive place or a sensitive location. Any type of sensitive place restriction had to be rooted in our nation's history and tradition. However, despite that decision, the state of New York decided to rush through a new law called the Concealed Carry Improvement Act, or the CCIA. Instead of rolling back their concealed carry laws, the state doubled down on gun control and created a scheme even worse than the one that existed prior to that Supreme Court decision in Bruin. This new law in New York created a more restrictive application process and then made it so that almost everywhere within the state of New York is considered to be a sensitive place, effectively making it almost useless to even have a permit because any business, any property owner would have to affirmatively tell you that you could conceal carry at that location. Because of how this law directly violated the Second Amendment and what the Supreme Court just said in Bruin, GOA, or Gun Owners of America, filed a lawsuit against the state of New York. In the original lawsuit, Antioch v. Bruin, GOA asked the district court for a preliminary injunction against the enforcement of this law. A preliminary injunction is an injunction that may be granted before a trial with the goal of preserving the status quo while the case is actually being heard. So GOA's goal with that original preliminary injunction request was to stop this law in the state of New York from going into effect, which was going to go into effect in September 1st, and ultimately did go into effect because in response to that original lawsuit, the judge there, Judge Sotheby, decided to dismiss the entire case because he said there was a lack of standing. However, in that same order where he dismissed the case, he did run through the analysis for a preliminary injunction, stating that if he could rule on the merits of the preliminary injunction, he would find that the state of New York's law does in fact violate the Second Amendment and does not adhere to what the Supreme Court just said in Bruin. After the case was dismissed, there was a question about whether or not GOA would just simply appeal that or would they try to refile the case, and ultimately they decided to refile the case to try to fix some of the plaintiffs, add some plaintiffs to fix all those standing issues, and then relitigate the case. Then on refiling the case with the new plaintiffs, GOA also requested a temporary restraining order and a preliminary injunction to stop the enforcement of this new concealed carry law. The last time I covered this topic in a video, it was to let you know that the judge here, Judge Sotheby, did grant the TRO restraining the enforcement of various aspects of the New York concealed carry law that they just put into effect. First, he found that the good moral character standard was invalid. One of the primary reasons was that he stated under Bruin, the Supreme Court endorsed a standard that compels a state like New York to issue a carry license unless the licensing officer finds that the applicant is likely to use the handgun in a way that is maybe dangerous to himself or to someone else. He pointed out that this new good moral character standard that New York was using and was pushing for was essentially the same type of proper cause standard that the Supreme Court just struck down in Bruin. Judge Sotheby simply stated, instead of moving toward becoming a shall issue jurisdiction, New York State has further entrenched itself as a shall not issue jurisdiction. In doing so, it has further reduced a first-class constitutional right to bear arms in public for self-defense into a mere request. And because of that, he granted a TRO against the good moral character standard of the CCIA. Then he looked at other aspects of that same law, the CCIA. He restrained the enforcement of the law requiring a list of family members and cohabitants to be given when you're applying for the license. He also said that the police officers, the state of New York, could not go in and look at social media accounts. You weren't required to give a list of social media accounts. That was also invalid. And he also looked at the in-person meeting requirements and found that the in-person meeting requirements also had no historical basis, and therefore also he found that that was invalid. He also looked at the sensitive place restrictions that the state of New York put into effect with this law. He found some areas like federal and state buildings, polling places, schools, churches, those areas may qualify as a sensitive place. However, he found that the new law and the general restriction on concealed carry in all locations, unless the property owner or the business owner grants permission to carry, he found that aspect, that catch-all provision within this new law, was in fact invalid and granted a TRO against the enforcement of that aspect of this law. Also important for New York was the finding that restricting concealed carry on public transit, subways, ferries, taxis, and all of those types of locations did not have any historical support, and therefore he also restrained the aspect of that CCIA in regards to public transportation. So after going through the CCIA, the judge temporarily restrained various aspects of the application process and also various sensitive location restrictions. The decision in regards to the TRO wasn't perfect, but there were a ton of solid wins that came out of that granting of the TRO. Now, in that same order, the judge also issued a temporary stay on his own judgment. The stay was in place for 3 business days, which gave New York time to appeal the granting of that TRO and also gave them time to seek an emergency stay of that same TRO. Now, the Second Circuit did grant an interim stay on the TRO, which means that essentially they are preventing the TRO from going into effect until the Second Circuit has an opportunity to actually hear the request for the stay on the granting of the TRO. At that point, the Second Circuit can grant this stay that the state of New York is requesting, or they can ultimately deny it. The interim stay essentially maintains the status quo until the Second Circuit can actually hear the request for the stay pending the appeal. So that is how this case is currently shaking out in regards to the Second Circuit level, but there is also other proceedings that are going on in regards to the district court level, and those are proceedings going towards a preliminary injunction hearing. Like I mentioned earlier, a TRO is limited in time frame. The plaintiffs in this case want a preliminary injunction because that would bar the enforcement of the law during the entire duration of the case. Also, if the court grants a preliminary injunction, that also essentially signals that the court will likely side with the plaintiffs when the case is ultimately decided. Now, the state of New York has already filed its opposition to the request for a preliminary injunction, for that motion for a preliminary injunction. I won't bore you with all the nitty-gritty details and arguments that the state of New York puts forward in their opposition, but one of the important things that I want to point out is the fact that the state of New York is already including in their opposition that if Judge Sotheby grants a preliminary injunction in favor of the plaintiffs, he should do the same thing that he did when he granted the TRO. He should stay the enforcement of the injunction for 3 days and give the state of New York time to seek a permanent stay and to also appeal that decision. So that's a quick rundown of where this case currently stands in regards to the state of New York's new concealed carry law that they passed in defiance of the Supreme Court's ruling in Bruin. This is a case I'll definitely be keeping my eyes on, and if I get any more information, I will let you all know. Also, if you have any questions, like a common question if I'm a robot, you can go ahead and leave those comments down below and I'll try to answer the best of my ability. And of course, the answer to that is yes, I'm a robot. So if you guys like these videos, like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys directly impact these videos, impact this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.